Hello. In this video, I want to explore an aspect of the relationship between administrative justice and human rights. As you know from my previous video, at the University of Sussex in the law school, we place the study of administrative justice at the heart of our study of public law, at least for part of the module. To get the most out of this video, you first need to be aware of two things. First, that the United Kingdom is signatory to an international treaty, the European Convention on Human Rights, or ECHR, that grants all persons certain rights in this country and indeed throughout Europe. And second, that UK law provides a framework for enforcing convention rights domestically through the Human Rights Act 1998, or HRA as we sometimes call it. In understanding the relationship between human rights and administrative justice, a key statutory provision is Section 6 of the Human Rights Act. Section 6 says that it is unlawful for a public authority to act in a way which is incompatible with a convention right. That simple phrase brings human rights directly into the world of public administration. It means that public bodies, from government departments to local councils like Seaford Town Council, must comply with human rights obligations in their decision making. But how far does this duty go? Does it require public authorities simply to avoid outcomes that are incompatible with human rights? Or must they actively consider rights whenever their decisions engage convention rights, that is, rights protected by the European Convention on Human Rights? This question became the subject of a number of important judicial decisions in the decade following the introduction of the Human Rights Act. We will look at one of these cases in a moment, but first, let's pin down exactly what Section 6 says. Section 6, subsection 1 of the Human Rights Act provides, "It is unlawful for a public authority to act in a way which is incompatible with a convention right." So the first thing you might ask is, who is bound by this duty? Section 6, subsection 3 makes clear that it covers central and local government, police, NHS bodies, schools, and also courts and tribunals. It even extends to some private bodies when they are exercising public functions, although we're not going to look at this today. And there are exclusions. The Section 6 duty to act compatibly with convention rights does not include either House of Parliament or anyone exercising functions in connection with parliamentary proceedings. Now, you could watch my video on parliamentary privilege, and you'll see that I argue that this is a modern form of parliamentary privilege, analogous to Article 9 of the 1689 Bill of Rights, and you will learn about a case involving Mohammed Fayed, once the owner of Harrods. But that's a digression. The point here is that Section 6 extends across the vast range of everyday encounters between persons and the administrations. Benefit decisions, planning permissions, police operations, decisions about whether school children can wear Islamic dress, and as we're about to see, the licensing of sex shops. So you might ask, what exactly must a public authority do to be compliant with its duties under Section 6? And when the Human Rights Act first came into force, two interpretations seemed possible. The first was an outcomes-focused view, which said that public authorities must avoid in their decisions results that violate convention rights. And according to this view, as long as the outcome is compatible with convention rights, courts need not be concerned with the reasoning process of public bodies. The second view is the consideration view. And this view holds that whenever a decision engages a convention right, the authority must actively turn its mind to that right in the decision-making process. In other words, it must weigh the right's implications explicitly when deciding matters under its discretion. Remember, many convention rights are qualified rights. That means they are not absolute. Interference with certain rights is permitted, provided that interference is lawful and proportionate. So the real difference between these two views is whether the public authority must perform that proportionality assessment itself as part of its decision-making process, or whether it can leave that assessment to the courts if it's challenged later. The distinction is important. The first approach treats rights as a back-end check. The second embeds them as a front-end discipline in public administration. To see how the court settled this matter, let's consider the fate of an emporium dedicated to the sale of articles aimed at enhancing erotic enjoyment, trading as Miss Behavin Ltd. Miss Behavin wanted to open a licensed sex shop in the centre of Belfast. Belfast City Council refused the licence, relying on legislation that gave councils a wide discretion to decide whether granting a licence was appropriate for the locality. The case was first heard before the Northern Ireland Queen's Bench, and then was appealed to the Northern Ireland Court of Appeal, where the case was decided in a decision given by Lord Kerr. The company argued that the refusal of the licence interfered with certain rights of Miss Behavin, with its right of freedom of expression under Article 10 of the European Convention, as well as its rights to peaceful enjoyment of property under Article 1, Protocol 1 to the Convention. And crucially, Miss Behavin argued that Belfast City Council had failed to consider these rights at all when making its decision. And the Northern Ireland Court of Appeal held that since the appellant's rights were a relevant factor to be taken into consideration, the failure to do so rendered the decision unlawful, unless the court could conclude that, had the decision been taken into account, it would not have changed the outcome of the application. In other words, even if they had considered the rights, the application for the licence would still be refused, and so the court argued there was no way of knowing that. In other words, Lord Kerr took the consideration view. Along with his colleagues on the Northern Ireland Court of Appeal, he held that when a convention right is engaged, a public authority is under a duty to consider that right when making its decision. It's not enough that the outcome happens to be convention compliant. For Lord Kerr, this flowed from the very purpose of the Human Rights Act, embedding rights into everyday decision making, not just into judicial review after the fact. But that was not the end of the story. Belfast City Council appealed to the House of Lords, and by a majority, the House of Lords adopted the outcome-focused view. In other words, it was sufficient that the Council's decision did not in fact breach the rights implicated, either Article 10 or Article 1 of Protocol 1, and that there was no freestanding duty on the Council to articulate rights reasoning in advance. The decision was not unanimous. Some law lords took the view that it would indeed be better practice for authorities to engage with rights expressly. The division shows that there was real judicial disagreement about how far Section 6 goes. The majority, however, carried the day, as majorities generally do, and together with the earlier decision in Begum, this established the prevailing interpretation Section 6 of the Human Rights Act requires compatibility of outcome, but not necessarily consideration of rights as part of the process. Now, I think that this is the wrong decision, although it is now a settled matter of law. And I'll tell you why. For one thing, I think that the consideration view squares better with the general principle that part of the duty on a decision maker when exercising discretionary powers is to take account of all relevant considerations and to be aware of and consider the factors that the law requires public bodies to take into account. But perhaps more importantly, I think it is necessary to look at what the Human Rights Act was trying to achieve. To see why, we can look back to the white paper that introduced the Act, Rights Brought Home, which was issued in 1997, a year before the Act passed. And the white paper made it clear that the purpose of the Human Rights Act was to bring rights into the heart of government and administration. It described rights as everyone's business, not something left only to Strasbourg or to the higher English or other UK courts. And on that understanding, Section 6 was designed to create a culture of rights, to inculcate a duty on public administrators, not merely to avoid violations of rights, but to integrate rights-based reasoning into everyday governmental decision-making. And so I feel that the House of Lords' narrow insistence on the outcomes-focused view risks hollowing out that design. So why does this matter? It matters because this debate speaks directly to the connection between administrative justice and human rights. If you adopt the view the House of Lords adopted, and let me reiterate, that is now the settled view, human rights becomes a backstop judicial remedy. Courts can correct the outcome after the fact, but they do not discipline the decision-making process itself. But were the House of Lords to have adopted Lord Kerr's approach, this would have helped to undergird human rights as part of the everyday ethos of public administration. They would have helped to ensure that human rights were a front-end consideration whenever a decision engaged human rights, such as the freedom of expression, religion, privacy, family life, and so on. So, to conclude, as the law now stands, the House of Lords' judgment in Miss Behavin and in Begum means that Section 6 does not require public authorities to consider rights as a matter of process. They must simply avoid acting incompatibly with the Convention. The courts will not look at how they got there, as long as they do get there. But in my view, this was a wrong turn. The better reading is the one articulated by Lord Kerr. When a convention right is engaged, a public authority should actively consider it. That fits the purpose of the Human Rights Act as explained in Rights Brought Home, and it better reflects our wider traditions of administrative law in this country. The debate shows us two different conceptions of how rights interact with administrative justice. Legally, the House of Lords view controls. Normatively, the question remains whether we can recover the broader vision, where human rights shape not just outcomes, but the processes of everyday governance.